because there was a hearing with Turtleboy and Karen Reed that allegedly they tried to have without Karen Reed. So this will be the next subject. Where's my swoop? Yes, folks, that is my Norwegian fire farting dragon. You cannot sneak up on that from behind. So let's move on to, I believe, Friday morning or Thursday morning. When was it? Yeah, something of the sort. Let's see. Let's play it back from the start. This crossover was so good. Yeah. So let's go into the Karen Reed case. Dun, dun, dun. Thank you. Yesterday morning. And thank you, Alan Jackson's bucket of nickels.
To obtain a Rule 17 subpoena to pursue or obtain other information available in a separate case. But these are a bit unique in circumstances in that I am a specially appointed prosecutor to Karen Reed's case, Commonwealth versus Karen Reed, and Judge Cosgrove, Special Prosecutor Cosgrove, is specially appointed to Mr. Carney's case. Because of that, I have, from the beginning, kept a very strong line of separation between both Mr. Carney's case and Ms. Reed's case. I have only sought information that's been publicly available, and that's why my motion cites a search warrant, an affidavit in the search warrant, and there are 2 pleadings as well in my motion that are on the public docket. And so what I learned is from my public reading and from watching hearings. And so what I know is that there are 2 phones that were searched by Trooper Tully and is in the possession of the Norfolk County District Attorney's Office, and the information is relevant material to Karen Reed's case. The reason why it's important and relevant is that separately, I possess information that establishes not only a relationship between Karen Reed and Mr. Carney, but a relationship in where information, some of it private, some of it suggestive grand jury minutes, was passed purposefully from Karen Reed to Mr. Carney. Originally, a third party was used, an intermediary, where allegedly Ms. Reed would send the information to the third party, would then be sent to
Counsel, let me stop you there. Has the name of the intermediary appeared in the public record?
I don't know that. I know that the attorneys are very well aware of that person's name.
Yeah. Special Prosecutor Breenan, you are not in front of Judge Bev. You will get interrupted. Hi, Purple Rain.
It may be, but I don't know that, and that's why I've refrained.
Let me ask you this, Counsel. Does the name of the intermediary appear in Trooper Tully's affidavit, either in the substantially itself or in the addendum A?
I will need to re-review, but it very well may.
Well, that's a critical issue here with regard to the purported relevance of the data sought. Let me ask you this, Attorney Brennan. Have the extraction reports that have been requested been generated?
I understand they are available to Special Prosecutor Cosgrove and that they have the reports that have been generated.
Has the underlying data from the 2 phones in question been assembled?
I understand that it has. I cannot personally confirm because I have not asked to review it personally.
Do you know the volume of the underlying data?
I have no idea because I've purposely not asked to see it or ask questions about it.
Okay. Please elaborate on relevance as it relates to consciousness of guilt.
Yes. As Your Honor is aware, consciousness of guilt is a different standard than trying to prove a case of intimidation of a witness beyond a reasonable doubt. What we expect evidence will show, separately and in Mr. Carney's phone, is that there was a relationship between Karen Reed and Mr. Carney. in which Ms. Reed would provide information indirectly and directly to Mr. Carney. That information would then be reviewed by Mr. Carney, posted on social media, and consequently was used, we believe, allegedly, to intimidate and harass witnesses.
To my knowledge, what he is arguing here was put in front of a grand jury. And when you put things in front of a grand jury, the grand jury only hears the prosecution's argument. And the grand jury still said, no, there's nothing here. We will not indict on these charges, on this speculation. And here he is again. Not him again, but him as a representative of the state is there again arguing the exact same thing that the state did in front of the grand jury, and the grand jury said no.
In the search warrant itself, there is extraordinary detail on how Mr. Carney targeted witnesses in Ms. Reed's case, with the express purpose, according to Mr. Carney, that this trial of Ms. Reed never go forward. We have a many-page affidavit that we have provided to the court. I can offer some of the most important parts if Your Honor would like.
Counsel, I don't think that's necessary. I've reviewed the affidavit in support of the search warrant thoroughly, and here's where I struggle. So the case law says the party seeking the data in question has to make a initial factual showing that it's relevant, not potentially relevant, relevant. That's the initial burden. So to demonstrate her alleged consciousness of guilt, defendants, don't the communications sought or the data related thereto have to only involve communications between Mr. Kearney and the defendant?
I'm not clear on your question, Your Honor.
How is anything beyond communications between Mr. Kearney and the defendant in this case relevant to her consciousness of guilt? Here's my issue. You have sought a broad swath of data. We don't know the volume yet, but it is from the addendum A to Trooper Tully's affidavit in support of the search warrant. It calls for data including calendars, alerts, reminders, notes, text messages, pictures, or videos from April 1st, 2023 through and including October 5th, 2023, 7 months of material that ostensibly could include everything from meeting notes, calendar invites, texts, videos, things that have absolutely nothing to do.
And here comes the Karen Reed defense attorneys. To my understanding, they were not told about this hearing. So they show up in the middle of argument that Special Prosecutor Breenan has about their client, Miss Reed. Let's watch this again.
Could include everything from
The
meeting notes, calendar invites, texts, videos, things that have absolutely nothing to do with communications between Mr. Kearney and the defendant. So how can the Commonwealth make the threshold showing that those are relevant?
First, this is a ruling with Mr. Kearney, so I'm asking that Mr. Kearney and his attorney be at the table. I'm not sure why we're being joined by Ms. Reed's team, unless they have standing in this.
Your Honor, we're a little confused, and I don't mean to interrupt the proceeding, but as we're...
Can you state your name for the record, please?
Of course, I'm sorry. Alan Jackson on behalf of... We didn't see which case number was called it was Rule 17, if it was Mr. Carney's case number, or if it was Ms. Reed's case number. We were told, or at least our impression in talking to Judge Cannoni, was if this issue was going to be on our case number. I specifically asked that question at sidebar day before yesterday, and she said, yes, the Rule 17 that Mr. Brennan's dealing with is on Ms. Reed's case number as it pertains to her rights. And the
This
issue
meeting is being
Counsel.
recorded.
Counsel, it has been called in this case, but I don't know that your client has standing with regard to this particular issue.
So the case number, I just want to make sure procedurally I'm on the same page as the court and Mr. Brennan and Mr. Carney. The case number that was called was the Commonwealth versus Karen Reed.
00117.
Okay.
That's correct.
Then she needed to be here and she has a right to counsel, and we have a right, we believe we have a right to be heard on this issue because it does attend to her rights going forward in terms of her case. I mean, this is her case.
I don't know that yes, it is her case, but what standing does she have to challenge a Rule 17 request related to documents produced in another case?
Because it specifically pertains to the prosecutor asking for information in her case to move forward, her consciousness of guilt, etc.
Those are evidentiary issues, counsel,
Correct, but we,
which can be dealt with at a later time. Those are what you're suggesting are evidentiary issues which are not before the court. All of it before the court is a Lampron hearing on material sought from Mr. Kearney's case. The evidentiary issue will be dealt with at a later time.
I understand, and respectfully, I don't necessarily disagree that from an evidentiary standpoint or the disability standpoint, that can be dealt with at a later time, but the case should never be called without my client being here. She has a constitutional right to be here and to be heard, even on a Rule 17. The Commonwealth there's been Rule 17s for 2 years on this case, over and over and over, Your Honor. The Commonwealth has taken positions on Rule 17s. We've taken positions on Rule 17s dealing with third-party information, be it cell phones or text messages or whatever. I'm only asking that we be entitled to be heard on this issue, even though it deals with Mr. Carney's phone and he's got legal representation. It also attends to Ms. Reed's rights, and it's her case number. And the reason the Commonwealth is trying to bring it in is to deal with her case, not Mr. Carney's case. So she has to have a right to be heard.
Counsel, this motion's been pending for a week and a half now. I don't have any opposition from you. I don't have any submission from you.
We intended to submit oral argument as it attends to, and we're
And
prepared.
did you give the court notice of that?
We did to Justice Cannoni,
Okay.
day before yesterday.
And what do you propose, counsel?
The only thing I propose, I don't want to interrupt Mr. Brennan's argument, but when Mr. Brennan is finished, Ms. Little is prepared to address the court on the very issues that Mr. Brennan is bringing up.
I'll take it under consideration. Is there any issue, counsel, with the current configuration, of the court, such that that causes any issue for any of the parties?
No, absolutely not, Your Honor. Again, I will step back. I will be a little mouse in the room. I just need to be in the courtroom. And once Mr. Brennan is finished, before the court makes its ultimate ruling, and once Mr. Radel is finished, I think we should be provided an opportunity to be heard.
I'll consider the request.
Okay.
Judge, I have no objection procedurally. The counsel wants to join in my file. That's an issue in terms of the filing. So just put it
Thank
down.
you. Thank you,
Well,
Attorney.
Your Honor, I do object. Ms. Reed's counsel and Ms. Reed do not have standing for this motion. I don't believe they should be sitting at the table for this motion. It's a Rule 17 motion of third party. She has no privacy interest in these materials. She has no standing to object, and she's not a party on the Rule 17.
Thank you, ADA Brennan. She is a party in this case, and I'll allow her to sit at counsel table and to have representation, and I'll consider whether I'll hear from her counsel concerning the substance of the motion and her
Thank you, Your Honor.
considerations there
We
too.
appreciate the court.
Yeah. Procedurally, judge is absolutely correct. Absolutely correct.
For accommodating us.
So, ADA Brennan, with the court's apologies for the interruptions, the crux of the issue, as I see it, with regard to relevancy and the Commonwealth's burden at this stage to show that the requested materials are relevant involves the breadth of what has been requested. And perhaps you could speak to that and how materials that would be swept into this request are in fact relevant.
I understand the court's concern, and I've looked at Addendum A as well, and have identified the information I think is relevant to the Rule 17 subpoena. So I agree the Rule 17 subpoena speaks broadly, but what is relevant is sections D, E, and F. Now, mindful that there was...
If you knew from the very beginning you were overly broad, why are you here saying we're only actually going for these parts?
probable cause to obtain this warrant, which is a far stronger standard than what is needed for a Rule 17 motion.
Counsel, pardon me, did you say D, E, and F of Addendum A?
Yes. So if we look at Section D, there was probable cause granted for communications between Mr. Kearney and any witness or family members of witnesses involved in the murder of John O'Keefe, to include but not limited to Matthew McCabe, Jennifer McCabe, Brian Albert, Christopher Albert, Colin Albert, Juliana Albert, Michael Proctor, Elizabeth Proctor. And so limited, including but not limited, would suggest any witnesses in the Commonwealth versus Karen Reed case. E is pictures or video depicting evidence of intimidation of a witness. So similarly to D. And F, data evidence disseminating data depicting evidence of intimidation of witnesses of those same people. And so D, E, and F are squarely on point and relevant to the Commonwealth versus Reed case. If there is probable cause to obtain a search warrant, believing that there is information of those three categories on those phones, then I believe we're entitled because we'll clearly have met our burden of proof, not only because a Rule 17 is that it's likely relevant, much less than probable cause, but because of all the attendant information that we've provided. There is...
Hey, Brennan, let me stop you again. Would any of those categories include communications from Mr. Kearney with counsel from Ms. Reed?
I see in the chat you're discussing how Turtleboy and his actions. Now, Turtleboy has been an amazing advocate for Karen Reed. Without him, most of us would not have heard about this case. With that said, the latest stunt outside the pizzeria, no, just no. Because at a certain point, advocacy can go overboard. It looks bad. And I admire Turtleboy for all the work that he has done in this case. I truly do. I do believe that he should be under the First Amendment freedom of the press. Because my interpretation, and a lot which is agreed upon of a lot of constitutionalists, is that freedom of the press is the literal printing press, not the person, the printing press. The printing press then went on to new medias as radio, TV, and now different internet forums. It is not about your education as a journalist, because that's kind of a modern thing to actually be a trained journalist. It is, for instance, in my opinion, me converting this information to you guys over YouTube and Rumble. That should be including in freedom of the press, because I'm using a medium to tell news and opinions through the medium of internet and different platforms. It should never be limited by any court anywhere to you have to be a person with a publication or a person who works for whatever damn newspaper. No, freedom of the press is the literal printing press. Who happens to have a printing press should be acknowledged as under the freedom of the press statutes. If you have a printing press from 1812, you do your flyers or your 2-page newspapers or whatever's, you are under the First Amendment freedom of the press statute. Now, it has changed lately by judges who say you have to belong to an accredited news organizations. Accredited or reliable? Who? CNN? We watched 2 months ago, a defamation suit against CNN. And they lost millions because of defamation. No, folks, freedom of the press is not about the person. It's about the medium. Speaking of medium, Dave's back.
Oh,
hi,
there we
Dave.
go. Hello.
Hmm.
Who is Turtleboy? Turtleboy is a blogger turned YouTuber. He doesn't call himself a YouTuber. He's an investigative journalist. He's been covering the Karen Reed case. We had him on my channel twice, I think.
Mm-hmm.
And it's unfortunate what he's going through. But I give him props for keeping it going and not backing down.
Mm. Yeah. Now, his latest stunt when he went up to the pizzeria and started screaming things or saying things. Yeah. But again,
Well,
I agree. Yeah. That's not a good idea.
no, not the best.
No. So at one point in time, yes, you're doing a lot of good work, but at some point, if your advocacy is too strong, it might stop actually helping. Now,
Well, that's
this is
the
a
thing.
one.
I mean,
Mass is a one-party state, so it shouldn't be considered anyway.
No, I think it's a two-party consent state.
Is it
if I'm not
okay?
mistaken.
2 parties. So
Yeah.
both him and
His
That's
attorney
possible.
actually, so his attorney actually wrote a letter to the Commonwealth's the DA or prosecutor or whatever, and said, hey, because what's his name was recording him, that's actually a violation of law, and we insist on you. We want to pursue charges, and we want to we want you to charge him with the crime for not getting both parties' consent to be recorded. I mean, it was just for show. I don't think they actually expected it to go anywhere. They were making a point, like, you're charging Turtleboy with all these things, yet you won't charge someone who's obviously breaking the law. They charged it, with illegal wiretapping and stuff. Yeah. So, that letter was to Canton PD. Okay. So I knew, but they wrote a letter because it is apparently a two-party consent state. Now, I believe that in the public, if you're in the public, then you don't have a right to privacy to that extent. If somebody records you, someone records you. So I don't think that argument's going to go very far, but they've been using it against other people, which is, I mean, if you're going to use it against other people, then use it against one of your big witnesses in this case. Yeah. And city alderman or whatever he is.
Yeah. Then again, I mean, there's a lot of things that has been said on camera by these now officially third-party suspects. I mean, they have been recorded saying a lot of stuff. Will that be included in public, which they have said allegedly in public?
No. Well, you mean the other people against Turtleboy?
Yeah.
Well, it won't be, but it should be, right? If it's good for one, it's good for all. That's, I think, the point that they were trying to make. You can't have it both ways. You should have one rule and it applies to everybody. That seems fair, right? We can all get behind that. But that's not the way they're applying it.
Yeah. And one of my, this is one of my big, what do you call it, pet peeves, is the hypocrisy. That you can bring on, I mean, the world's best expert the what's the name? I don't remember the defense doctor. What's her face?
The pathologist or whatever.
Yeah.
Yeah.
She had to go through an excruciating 2-day Daubert hearing. But when the state says, "Hey, we're bringing on this dog behavioralist,"
Right.
she just approves it.
Yeah. See, that's the problem. And Kurt from Uncivil had a great little rant that he did. He was like, "Listen, I don't care what you think about the Karen Reed case. Let's just try to figure out the rules, right? Us as attorneys, we'd like to know what the rules are because that's how law works, right? There's certain rules. You follow the rules, things get admitted. You don't follow the rules, things don't get admitted. But here, there's no rules. It's just random.
Yeah.
And that's not a good system. That's not a good judge if it's just random."
Yeah, we just watched the absolutely amazing walk-in from the Karen Reed's defense attorneys in the middle of special prosecutor Breenan. And it was, yeah.
No, I think those would be privileged. Secondly, there are motions filed in this case, not Karen Reed case, Mr. Carney's case. One is the Commonwealth's opposition to defendant's motion to suppress and to restrain any searching of a computer or telecommunications devices. This was filed by Special Prosecutor Cosgrove. And in that motion, on page 5, he notes that the 2 phones that I'm seeking information from have already been searched. And he also notes in the motion that there does not appear to be any attorney-client privilege materials. There is a second source as well, and that is in the Commonwealth v. Kearney case, docket number 53, Commonwealth revised proposal for examination of digital material seized. That's relative to the 4 phones that I'm not seeking. However, it's instructive because in that motion as well, it talks about the history, and it gives assurance that there are no attorney-client privilege communications in the 2 phones that I seek. And so, given the separate evidence that we have, and these are clearly witnesses in our case, and the admission by Ms. Reed herself, I do not have the video, but she was recently on an air broadcast on a documentary last night, the night before, and the night before. There are admissions that she was, in fact, providing information to Mr. Kearney. And what is notable is that she specifically reflects upon the consequence of Mr. Kearney's actions, which she helped fuel by providing this information and identifying the witnesses in her case. I do have a clip, if the court is interested, because it gives great depth and understanding to the intentions of the party in sharing this information. I have a clip available. If the court wants to hear it, I can play it for the court.
I don't think that's necessary, so I'll decline respectfully the offer.
First of all, let's use this as an example of, even if you're Karen Reed, you don't say anything to anyone about anything ever. Because here's a good example of where it's an innocent remark and now the state is using it against her. So just don't talk. Don't talk about the case at all, period.
Yeah. And I just had it up here on, because the Commonwealth has filed a motion to compel communications between defendants and Attorney Janetti. Apparently because Karen Reed briefly mentioned something she told him as an attorney.
Well, that's not her attorney. So,
No, Janetti is her attorney.
Oh, that's her attorney?
Yeah.
Or is it Turtleboy's attorney? No, Turtleboy's attorney is, what's his name? But, okay, so I don't know about that, turning over that stuff, because that's breaching a line. I'm not looking at it, so I don't want to comment.
Hold on, I think I have it. I have the motion.
I was like, because if they want communications with Turtleboy's attorney, then they're going to get my emails.
Let's see here. Hold on. Where is it? Commonwealth's motion to compel communications between the defendant and Attorney Yannetti stored within the defendant's cell phone data.
What?
Yeah. So this was just March 21st. So today, your time.
But is it going to a discovery master, or is it being turned over to the Commonwealth?
Jesus Christ.
So for those who don't know, sometimes the court will appoint what's called a discovery master, who is a third party, not associated with the case, that will review everything for things that are privileged, confidential, or for other reasons shouldn't be turned over. They're not relevant, things like that. And then whatever is relevant and not privileged will be then turned over to the other side. So that's why I'm wondering if this is going to be turned over to the discovery. Is there a discovery master?
I'm not sure. But here's the thing. It's Judge Bev who decides. So why take the risk?
Voluntarily and intentionally disclosed the existence of those communications to her and her initial thoughts about her culpability for causing death to John O'Keefe. Really? So they're going to try to get at this through this consciousness of guilt thing. Like, oh my God, I killed him. Oh, or I'm going to flee the country or whatever. Those are still privileged communications.
Let's see here. Waiver of privilege.
Yes, the Taint Team, Special K.
Yeah. Let's see here. They say, in this case, the privilege holder, the defendant, has clearly and intentionally waived her attorney-client privilege regarding a specific conversation she had with Attorney Yannetti regarding his collision between her vehicle and John O'Keefe. For example, in the recorded interview with Gretchen Voss, question: you never said, "Did I hit him?" I hit him. A as in Karen Reed said, did I hit him? And then, when I talked to David, now this is later, David said, Karen, if you incapacitated him in any way, there's capability there. And I thought, all right, maybe this is what, maybe. I said to my mother, just to go forward a second, they were asking me, what was it like? Did they come out? What was the house like?
Okay, so this was my first thought. When I pulled up HBO Max the other day and I saw a documentary about this case, and then I saw that Karen Reed gave an interview, I thought that was a bad idea.
Yeah.
And this is exactly why. This is a bad idea.
Yeah.
Because you're making statements that the Commonwealth is now going to use against you to get at your privileged communication. Now, I still don't think that information should be.
Yeah. But the running question here is should. Judge Bev, for the past 2 years, everything the prosecution wants, they more or less get. That you have to. They shouldn't. But here's the reality: Judge Bev presiding. You have to adapt to that circumstance. So if you go on an interview and say stuff that you may or may not have told your lawyer, Judge Bev will rule against you.
Now, the other caveat here that's in the I don't know category, in Michigan, if somebody contacts me as a potential client, I have there's immediate confidentiality. Like, I don't have to pay them. Sometimes you see on TV shows like, hey, give me $1 so that there's an attorney-client relationship established. That doesn't exist in Michigan. If anybody contacts me seeking legal advice, there's an immediate confidentiality, and I can't disclose that to anybody. I don't know if it's the same in Massachusetts. So that's why, that might be another little wrinkle, because somebody said in the chat that she had another attorney retained early on in the case. And so maybe Yannetti wasn't her attorney, and maybe there's some weird loophole there. I don't know. But it seems really bad all around.
Yeah, because you know that Special Prosecutor Breenan, he will take any opportunity. He has lied in court on several occasions just to a day later file with a correction to the court. And she just brushes it off. She will find against Karen Reed, even if it in the most remote possibility she finds a case law, she will rule against. So these interviews are damning.
Yo,
Or
they
may not be
definitely are.
damning. Or may not be, because I saw that Turtleboy said, "Oh, they're going to see my text messages." Well, then they will also see, what did he say? That Jen McCabe sent him nudes.
Well, I mean, but the bottom line is you don't want to say anything to anyone about anything ever, because this is a perfect example of why you don't want to.
Yeah.
We talked about Delphi and why you don't ever want to talk to the police, ever want to talk to the police, even if you think that you have some information that might be critical to a case, because but for what's his name, the defendant, calling the police, he wouldn't have been charged.
If he didn't call in to help, he wouldn't be in prison now.
Yeah. So, and then put Bev on top of it. It's a nightmare, especially when you're dealing with that judge, that prosecutor. Just don't give an interview. I know it's tempting, and sometimes attorneys can't control their clients, and she really wanted to give an interview. And it sounds like she gave a couple. She gave one to Vanity Fair too, which, I failed to read my Vanity Fair for the last few months, so I missed that one. But I
kind of missed that. What was it? Vanity Fair? What's that?
It's a like a fashion magazine.
Oh yeah. I read those a lot. Can't you tell?
Yeah, I know. What was funny is when my stepdaughter lived here, we got those in the mail.
Oh,
she, because she had so we would get like Vanity Fairs and all these like lady fashion magazines and stuff. I haven't read them in a while, but just don't talk to anybody.
Yeah.
Anything you say, it's either going to be helpful to the other side or it's going to be neutral. It's never going to be helpful to you. So don't say anything.
Yeah, definitely.
Yeah.
And thank you,
Amber. Wait, was that pro? Oh, Vanity Fair was pro Amber Heard. Now, I wonder, did they put a spin on it? I kind of want to read this Vanity Fair article now. I'm wondering what sort of spin they put on it.
On Amber Heard? Or
No. I mean on Karen Reed's case. By the way,
see if I can find it.
I got my Buc-ee's mug. I brought it out just for you.
Oh, thank you.
It's going to be paid for. You're going to have to pay for it to read it online.
No, here it is.
Okay. Oh, really? Wow.
Well, at least the 2024 thing.
This is from 2024?
Yeah.
Oh. Murder trial in Massachusetts.
Oh.
It's like a Salem.
It's a 44-minute story.
Yeah, maybe we.
Yeah, I don't care. Let's go back. Yeah, and as Wendy H says, you have a Lego stream tomorrow.
I do. With Legal Vice's son is going to join us.
Yay!
Yeah, Connor's going to join us. So Vice Baby, you might know him by, or you might not know him at all, and you might just know Legal Vices. And so this is his son, Jeff, and he'll be joining us for a Lego stream tomorrow. So at 9 p.m. Eastern. So in about 24 and a half hours from now.
Yeah. And speaking of Lego, I've talked to
Steph. She's been messaging me. You guys got to do a rematch.
Yeah, because we didn't get head to head on the Lego, and I lost with, what was it, a minute?
Okay, wait a minute. I got to show you though. Let's see if I can present this. She Where's my mouse? There we go. She's not messing around, Nick.
I know.
She has. Wait, hang on. Can we share the screen?
Yeah, hold
I
on.
have 3. There we go.
Oh,
No, this one. Why won't it let me? There we go. Okay. So she sent me this. She's been building Lego and practicing. Look at all this.
oh,
She has been building Lego, preparing for the rematch. So you better step up your
really?
game, man, because you're representing me still.
Because I haven't built Lego since then, and
She sent this out to me the other day. I think on like Monday or something, and she's like, "Hey, look! I've been preparing for the rematch with Nick." So,
Darn
you
it.
gotta buy some sets and get prepared.
Oh, yeah. Or I might just not prepare, because if I win, she will look really bad, and if I lose, I have an excuse.
That's true. It's kind of like the Rocky and what's his name? The Russian.
Who? What? Oh,
In Rocky 2.
Rocky 2. Yeah,
He's got all
Dolph
that state of
Lundgren's
the
character. Yeah.
Yes, Dolph. Yeah, I can't remember his character's name, but yeah.
All right, let's continue to listen here.
ADA Brennan, thank you.
And so in light of the fact that this information was seized pursuant to a warrant of probable cause, in light of the proffer in the affidavit, in light of Ms. Reed's admissions of the sharing, and inevitably the obvious consequence to witnesses, this is relevant to conscience of guilt. The evidentiary basis is clear. I do not have access to this material if a Rule 17 is necessary. And again, I've filed the Rule 17 out of an abundance of caution to be beyond reproach. If it is not necessary, I will simply go and obtain the information on my own, but I think it's more prudent to have a court order. It's necessary before trial. I'd like to review the materials that are relevant, and I agree the scope should be limited to D, E, and F, not the entire phone. And those materials will be provided to Judge Cannoni in a motion in limine regarding conscience of guilt. Also, will dictate what witnesses we call at trial, which advance notice is important for both the Commonwealth and for the defense. It's in good faith. I provided
So
both
the judge gets
Mr.
to
Carney's
decide.
case, the search warrant affidavit in support of the search warrant. I've offered videos of the admissions by Ms. Reed to the relationship. And so for those reasons, I ask you.
What did you do?
Good morning, Your
That
Honor.
was the
Counsel.
stream, not me.
Judge, this is a Lampron request, is the case, and I know you're familiar with it, Your Honor. The purpose of the court's focus here, Judge, is on preventing unwarranted harassment of witnesses and third parties. The focus in Lampron as well is avoiding unwarranted delays. So this search warrant was done back, I believe, in February of 2024. So here we are at the 11th hour, and the Commonwealth is throwing, last-minute bombs out. I happened to look at the Reed docket last night. It's amazing to me how many motions in limine are filed. The government's trying to try that case through motions in limine versus, the immediacy of a trial. It was my impression of that. So, we're now getting sucked into these motions here at the 11th hour. And in terms of a Lampron analysis, Your Honor, there's relevancy, evidentiary, meaning there has to be evidence. As you said, not potential relevance, but actual relevance. Not otherwise obtainable at trial. You can't prepare for trial without it. And most important, Judge, is that the application is made in good faith and not as a general fishing expedition. This is the ultimate fishing expedition, Your Honor. And I want to go back. When this happened, Judge, we didn't have a dog in the fight back then. As far as my client and I knew, they were going after Ms. Reed for communications with my client on this witness intimidation issue. Well, counsel wants to tell you that, there was probable cause in a search warrant, but then they took it to a grand jury, so we're past that. They had the two easiest forums you can have for a prosecutor. Sitting in the judge's lobby, shooting the breeze with a search warrant affidavit in front of you and nobody else there. And then they went to the lowest hanging
You,
fruit.
not me. When you say you, not me.
Right, not you, Your Honor. And then they had the lowest hanging fruit you can get as a prosecutor, going to a grand jury without anybody else there, crafting the evidence in any sort of way they wanted to. And thankfully, and it doesn't happen very often anymore, but the grand jury said no. The grand jury said there is not probable cause. Again, the lowest hanging fruit in our system. They couldn't establish probable cause based on this information. And I remembered when this happened, just sort of not even so much representing Mr. Carney, but just as a constitutionalist, as a person interested in the Constitution, as an attorney, I saw this. I read the search warrant, out of the Herald or something, and I was prompted to write this press release that I sent out about this exact issue. And I went back to it. I looked at it again this morning, and it really covers exactly what's going on here. And in that search warrant, Your Honor, it's very clear that the government just wrote a 30-page short story about its efforts to try to find and isolate, and you have it in there, right, to find and isolate communications. And the government wants to criminalize communications. And if you look at my press release, and I'll submit it, or I'm just going to read a few things from it. We have in this Commonwealth a very special provision in our own Constitution that Ms. Reed has the right to present all proofs. And she has the right to fight any way she wants and talk to anyone she wants and communicate with anyone she wants and say, hey, don't share this. Hey, keep this between us. That's her right, her constitutional right under the Massachusetts Declaration of Rights to present all proofs. So when the government cites that just as a bare proposition, she tried to keep this secret. She communicated with Aiden Carney. Then we're going to make this gargantuan leap that she's sharing the intent to intimidate witnesses. So the whole thing is completely bereft of any evidentiary value, Your Honor. Just the notions that they put in the search warrant, and ultimately the fact that they tried to use it to get an indictment and fail. So that's why this has no evidentiary value. The relevancy is zero because they can't put it into evidence. And then further, Judge, as a practical matter, I looked at the docket. I spoke with counsel from the Reed matter. It's my understanding, and everyone's here, and they can correct me if I'm wrong. The government agreed to not put anything in their case in chief relative to this issue about communicating with Mr. Carney and consciousness of guilt, unless it was, quote unquote, the door was open, which of course is sort of a proposition that is, out in the ether, and that ain't ever going to happen in this case, Your Honor. And so that adds to the issue of whether this is evidentiary or not. The government's already backed off. The government got a search warrant filled with nothing but investigative pronouncements. We took a trip to California. We talked to this lady, and they were communicating. All they say is they were communicating. They don't say, hey, let's really get that person, and let's get them off of this, and let's try to have that person not testify. Let's scare that person. Let's harass that person. There's no communications like that. They just have the fact of communications. And that's not evidentiary. That's not relevant. So, Judge, here, they just want to get in Mr. Carney's phones. We're not concerned about what's in Mr. Carney's phones. We're concerned about their bizarre interpretation of the witness intimidation statute that they will try to graft onto any communications in our client's phone, in my client's phones, Your Honor. So there's a few more complicated things, Judge. I feel like you have it, but I just want the court to be aware, having come into this case at this point, there's a pending motion to dismiss with Judge Doolin, basically saying that all these witness intimidation allegations don't cut it under the Constitution, under the First Amendment. So that's pending, number one. Number two, Judge, is this taint team issue. Counsel's doesn't have it right. Went to say that, these first two phones, we already got into them. So the taint team covers everything, all of Mr. Carney's phones. So the fact that the state police snuck in and forged ahead and searched some phones before the taint team could get set up should not inure to the benefit of this Commonwealth. And this is a firewall type of a case with respect to a special prosecutor on the one side and the Norfolk County DA's office on the other side. A Rule 17 motion is absolutely required here, Your Honor. That's the whole point of keeping this confidential and separate. So the Rule 17 territory is entirely appropriate, Your Honor. In terms of...
Counsel, what's the legal import of the pending motion to dismiss
Sure.
in Mr. Kearney's case?
Sure.
How does that change either the relevancy analysis or the evidentiary value analysis in this case that I must make in the Rule 17 context?
Sure. So we expect Judge Doolin to come back with a decision that says all of these communications, maybe they're distasteful, maybe they're obnoxious, maybe we don't like them, they're all protected by the First Amendment. So let's look at the search warrant. They're looking for communications between Ms. Reed and Mr. Kearney. They don't even have that much. They don't have quotes. They don't have communications. They just have the idea that, well, they communicated. The fact that they communicated cannot be a basis for a criminal investigation, and it's the extraordinary step of getting into the phones. A couple of quotes on the cell phones, Judge, just to set the context. This is what from Commonwealth versus Onyx White. That is a landmark case that involves the notion, and you know, the government is always pushing the envelope, Your Honor. That case was very dangerous. The government was trying to set up a state of the law where just because we all have cell phones in our back pocket, in almost every case, let's see in that cell phone whether they communicated about a crime. And it would have been an unbelievable expansion of government power to search people's private information. Thankfully, the SJC said, no, you need to have a nexus between the phone and the crime. And they cited some other cases in terms of quotes about cell phones. Just two quick quotes, Your Honor. The cell phone is a repository of just about everything that is materially important to a possessor. Documents, messages, emails, notes, thoughts, communications, photos, loved ones, information involving loved ones. The court should not view lightly what the Commonwealth is seeking here. Cell searches would typically expose to the government far more than the most exhaustive search of a home. So
I appreciate that, counsel, but at the same time, the phone has been searched. The data has been obtained by the Norfolk District Attorney's Office. It's in it's in Special 88 Cosgrove's possession, custody, control. It's already been seized. 88 Brennan is looking now, it seems, for a very narrow subset of that information that does not contain the long list of materials that you just rattled off from the Onyx White case.
But it never should have happened. The search never should have happened.
That issue isn't before me, counsel. That issue isn't before me. The issue before me is what he's looking for relevant.
Right. What do they have? What do they have to set that up? They have the fact that they spoke. And the fact that they spoke is not evidentiary. It's not relevant. If the fact that they spoke was the basis, we'd be at Onyx White. We'd have the wrong decision in Onyx White, Your Honor. That just because people speak, the government gets to ferret around in their phones. It's a horrifying concept, Your Honor. That's really the crux of why I'm here. And the last thing I'll say, Judge, is that the fact that they got around the taint team we shouldn't just forget about the taint team. These phones need to go back through the taint team if they want to look at them. And on the taint team issue, there's more litigation to be done where the court already allowed scrutiny of the phones by a taint team for attorney-client privilege information. And my client at the time had many civil and other cases going on at the time. So Attorney Cosgrove's statement, there's no attorney-client privileged information in the phone is ridiculous. There's a ton of it. We're also asking right now, Your Honor, for the taint team to scrutinize the phones for, we're going to ask for husband-wife communication.
You're not asking?
No, not you. Just so you know what's out there. I just want you to know what's out there.
I understand.
We're asking for husband-wife communications. We're asking for the journalist source materials, of which there's a plethora. We're asking that those be scrutinized by the taint team and all that stuff be taken out. So the taint team issues are still in flux. You know, the fact that they did this, the court should deny this, Judge, just on the fact that this is an 11th hour request. If you look at Lampron, it talks all about undue delay. They had this back in February of 24, and here we are now on the eve of trial on their case. So for all these reasons, Judge, we object. This is a gross invasion of privacy. It's a fishing expedition. There is no hook that they have to say, we will find something criminal in those phones. Thank you, Your Honor.
Thank you, counsel.
Oh, can I comment on one of the
88
chatters?
Brennan, before I
Pause it real quick. Someone says, isn't information obtained unconstitutional makes it fruit of the poisonous tree? Yes, but a warrant is the appropriate way. Like the Constitution says, nothing can be searched and seized essentially without a warrant. And so if you can obtain a warrant, then it's not unconstitutional. And they're seeking a warrant right here. And like the judge already said, this information has already been obtained. It's just, it hasn't been released to these particular prosecutors. They're asking for a small subsect of it. And so really what the argument is relevant.
Yeah, but in this, if this has already been through a grand jury, doesn't that negate the probable cause in the search warrant?
Well, it went through a grand jury for Turtleboy, right? It didn't go through it went through a grand jury with, no, it wouldn't have gone through a grand jury with Karen Reed. It went through a grand jury with Turtleboy. So it's a different case.
Oh.
You know, this is pertaining to Karen Reed. So with the
Welcome
Commonwealth's
to
argument
judicial nitpicking.
Yeah,
101.
right. Well, so the stupid position, in my opinion, the stupid position that the Commonwealth is taking is that Karen Reed is guilty. She expressed this guilt through some statements that she made, and those statements might be contained in messages to Turtleboy from her. So we want access to that information. That's essentially what they're saying. Now, so the question is that enough of a relevance to allow this? Apparently, the judge agreed that it is, and it's going to go to Bev for review, which is scary to think about. That's what we're talking about. So I don't have the order. I know you pulled up part of it, and so maybe there will be some restrictions as far as
I didn't put up just the
that article. You put up the other article, which is the communication between Karen and her attorney, which.
Yeah, but I do know that he essentially approved it going through a taint team, more or less. Yeah. That's my understanding of it, at least.
So I haven't read enough to comment any further other than to just give you guys some general information. But what are you doing back there? You got things are banging around. Oh, you're opening a beer.
Yeah. I'm going into Highland Rock or Highland Jock. Strong British Ale. Nice. And thank you to Wendy for gifting 3 cups of coffee over at buymeacoffee.com. If you want to support my channel and what I do here, and also sponsor my trip to the United States, where I will go to Utah in September for 2 weeks. What?
Are you going to go to Moab?
I'm going to visit places of
Salt Lake City.
movie, the touristy stuff. And I already bought the plane tickets. I already bought the first 2 days in a hotel. Now, currently, I am going for a camper van so I can drive around Utah.
What days are you going to be there? I need to put this in my calendar.
I will land in Utah on September 3rd.
September 3rd. And when are you flying out?
I'm flying to Miami on September 17th.
I'm just putting Nick in the country. That's what.
And then from in Miami, I will be meeting up with Steve Gosney and Val Friedman down in Florida. Val Friedman is the attorney who won the defamation case against CNN, which I covered a couple of months ago.
Nice.
So we'll meet up with him also. And then I will fly back on September 24th. So if you are in and around Utah, I will try to make some kind of meetup. Or if you're in Miami, I will also do that in some way, shape, or form.
I'm going to
And if
be
you
in
want-
LA. I'm going to be in LA September 12th through the 21st.
Yeah, let's meet out in the desert.
That sounds good. I'll dig a hole and then we'll meet out there.
Yeah, and of course, while I'm in Utah, I'm going to visit Jeff's grave, and also meet up with Connor. And I also spoke with Donnie on, and one of the weekends there I will be spending with them. And by then, she has had her baby.
Oh, that's right. Yes.
Yeah.
I only see her from like the chest up, so I forget she's pregnant.
Yeah, I mean, a stream a couple of days ago, she showed her belly.
Did she?
Yeah. Aw.
Very cool.
Yeah.
I was on the stream with her earlier today.
Yeah.
On
Yeah.
my back law, yeah.
Yeah. Oh, well, today it was determined that Sweden just more or less removed freedom of speech.
Really?
Yeah. It is now a law against insulting civil servants, as in cops.
So you can't insult a government employee.
You can't see a cop and go this in Sweden.
Well, that's lovely. I mean, I don't know if I've ever seen a cop in Sweden. Actually, no, I did. I saw. Oh, did I tell you I got a speeding ticket last time I was there? First one ever. The stupid traffic cam driving down the road, and all of a sudden this bright light like blinds me, and my in-laws were in the car and were like, "Oh, you just got a speeding ticket."
Yeah. Yeah, our traffic cameras really said they will tell you if you are driving too fast by taking a picture. And this enormous, like, have you seen a camera from the 1940s with the big flash? One of those.
It's so bright. It blinded me going down the road.
Yeah.
But yeah, so I got a traffic ticket. Yeah. But I haven't seen a cop. I got a traffic ticket without seeing a cop.
Yeah. Problem with this law is it is insults against civil servants. Well, that includes politicians.
Yeah. So you can't insult a politician. Says how to make laws to protect themselves, right?
Yeah. So, yeah. Folks in the United States, protect your constitution, because once it's gone, it will never come back. First Amendment, Second Amendment, Fifth Amendment, 14th. Once it's gone, it's gone. Jesus Christ. Denver visit? Salt Lake City to Denver is 500 miles. I don't know. I'm just going to travel around Utah to the different movie sets in Utah. That is my goal with my visit. But I will be in and around Logan, Utah, and Salt Lake City, Utah.
If you want a cool little experience, in the middle of the Great Salt Lake is an island, and it's a state park, I believe. It's not a national park. But you can go camping out there. We went for a hike out there a couple of years ago, and there's wild buffalo everywhere. Like, I'm walking down a trail, and there's a buffalo. I'm like, I feel like I'm just going to, like, step a little around them. But you can camp out there in a tent with wild buffalo running around.
Okay.
Try it. And you could probably
maybe.
It's kind of a cool area.
Yeah, why not? I mean, my next goal is for the camper van, and that is between $100 and $150 a night, and I need a camper van for 12 days. So that is the next goal.
Very cool.
But let's get back to this.
Hear from you any further in response. I am going to hear from counsel for the defendant in this case.
It's going to be Attorney Elizabeth Little.
Thank you, Your Honor. Elizabeth Little, appearing on behalf of Ms. Reed. First, I just wanted to thank Your Honor for allowing us to be present and to be heard on this issue. The defense joins in Mr. Bradel's request in opposition to this Rule 17 motion. There's just two very brief points that I wanted to address that I don't believe were addressed by Attorney Cosgrove. Your Honor, if you take a look, Attorney Bradel, apologies, Your Honor. There are. Your Honor, the Commonwealth's affidavit in support of the Rule 17 is facially deficient as to both elements 3 and 4 of Lampron. The Commonwealth does not include a single fact in the affidavit to show that it cannot properly prepare for trial without the production of this evidence. So just on that basis alone, the Rule 17 is deficient. That's the same with regard to element 4. If the court looks closely at the affidavit that was filed in support of the Rule 17 motion, the Commonwealth is required to show that this is not a fishing expedition. The Commonwealth, again, does not set forth a single fact or even a conclusory allegation as to element 4. And that's because the Commonwealth knows full well that the grand jury has already rejected the Commonwealth's claims that Ms. Reed was somehow engaged in witness intimidation with Mr. Kearney. And on that basis, because it's facially deficient, this has to be denied. We therefore respectfully request that the court deny this Rule 17 motion.
Thank you, counsel. ADA Brennan, I'll hear from you in response briefly.
This guy's a little dweeb.
I think most importantly, the parties are conflating two issues. Whether there is probable cause or beyond a reasonable doubt to convict a person of intimidation of witness and the relevance to consciousness of guilt. It's two separate assessments. It is true there was a no bill, and it is true that there is litigation in Mr. Kearney's case, but these phones are in the possession of the district attorney's office. The information is available. It's been represented. There's no attorney-client privilege. There is nothing to slow down or stop the availability of the information. It is relevant for the judge in Commonwealth v. Reed to assess whether or not this information establishes consciousness of guilt. That is the issue, not the complaints or the concerns or the personal opinions, the constitutional prowess of Mr. Bradel. It is this reflective of consciousness of guilt?
Hey, Brennan, on that issue, on the consciousness of guilt issue, there was some suggestion there was an agreement that the Commonwealth was not intending to pursue introduction of evidence concerning that issue unless...
That is not entirely accurate. There was a motion filed by the defense, and they were concerned that when they were cross-examining witnesses in this case, that at the past trial that I was not at, the witnesses then offered to the jury that they were being harassed by social media bloggers, suggesting at the behest of Ms. Reed. That is an entirely separate issue than consciousness of guilt. I agreed that unless the door is opened, a witness should not get up and talk about their state of mind and how they believe they were harassed. I agreed to that because I will instruct the witnesses unless the door is open and you have an invitation, that would be improper. Separately, a consciousness of guilt motion in limine, which I expect to file if it's viable based on the information.
So what information do they expect to get?
Proposition. It's an entirely different proposition than open.
I don't know, but it is a fish. I mean, the claim from the prosecution is somehow she admitted something to Turtleboy. I don't think he would have reported the way he did if she admitted to anything.
But still, what exactly do they expect? Like, consciousness of guilt is like traditionally like somebody fleeing, right? If they're running away, first of all, consciousness of guilt is all like hocus pocus BS mind reading stuff, right? Oh, somebody, they said this, they got new cell phones. That means that there was something suspicious on their old cell phone or whatever. It's BS to begin with. But let's start with that premise, right? You're doing something that seems innocuous, but it actually shows that you believe yourself that you're guilty of this crime. First of all, it should only apply to intentional crimes, because accidental crimes, you don't have that consciousness, component to it. You don't have that intent. Mm-hmm. So So it shouldn't apply to accidental crimes, which this is being charged as an accidental crime. Even if it's second-degree murder, it's still accidental. And two, what do they actually expect to get from these communications that's going to show some sort of guilty conscience in her mind? I don't understand.
Yeah, I can't help you with that.